Good evening, everyone. My name is Scott Reich, and this is Crime Talk. Thank you for joining us on this Tuesday evening, June 6, 2023, for our Tuesday night live program. And we've got a lot to talk about. It's been a busy week. First of all, it just seems like June is already here. I cannot believe it. I mean, it just goes by so fast, so fast. It has been a long year indeed, to say the least. But we have a lot to talk about regardless. We've missed several weeks of broadcasting because of busy trial schedules, but I think things are slowing down just a little bit. And I've got one big 3-week trial in July and then another one in August. And I think that's all I have for a bit. Excuse me. It's water, ladies and gentlemen. Excuse me. It was water. So anyway, that's where we stand on that. But let's talk about the cases that you want to talk about, not my trial schedule. So what is of interest? Well, something I think is interesting is we've talked about the state of Idaho. And I know some people are getting tired of the Lori Vallow case. Some people are like, oh, Scott's going to talk about it forever and forever. But, well, there's always something to talk about with the Lori Vallow and Chad Daybell case. We talked about it earlier in the week that Chad got his trial date scheduled. Trial begins April 1st, 2024. I think that's ironic, April Fool's Day, that he starts his trial. But a couple of issues that relate to that, I think, also relate to the Brian Kohberger case. And what has shocked me is the level of secrecy that takes place in the great state of Idaho. Now, we have been to Boise. We have been down there to Madison County. Frank and I have jumped into Crime Talk 1 and jumped over there. We went over to see the trial. And Lori Vallow, we sat in the overflow excess room because the courtroom was full. And it just flabbergasted me that, the judges think that the world is stupid. And this just shows you the elitist nature of oftentimes the judiciary. Oh, you little minions, you little people, you don't know what you can't handle this. It's all this complex stuff and it'll be too emotional for you. And, you're not familiar with those big Latin words. So we'll let you know what you need to know when you want to know it, when we think you should know it. That's, the prosecutor and the judiciary are pretty much of that same cut. Okay. And so finally, and I don't know why, and maybe somebody can tell me why, that they know, I don't know. Why is it that there is a consortium of news agencies that are putting up a much bigger fight as it relates to getting cameras in the courtroom for the Brian Kohberger case than they did in the Lori Vallow case? In the Lori Vallow case and Chad Daybell case, the judge is like, no, I have complete discretion. And they just kind of went away. They're taking a much more aggressive approach, and my hat's off to them. And I also think it's interesting because, as you may recall, Lori Hellis wanted to get access and, all this information, but she was not an intervener. There are no interveners in criminal cases in Idaho, according to Judge Boyce. But these attorneys for this consortium of newspaper attorneys, or for newspapers and TV stations alike, they refer to themselves as interveners. So I think it's interesting. So Idaho legislature, you may want to go back and create some rules about broadcast in here. Now, as it relates to broadcasting cases in Idaho. And I think that this is a pretty well-written brief, and not to bore you all with it, having me read it to you, but I think it's significant. And just kind of glean back here on what they're asking for, why it's relevant for the citizens to have access to this information, and think of what a stretch it was for the judge in Lori Vallow's case, not to release the audio or anything, only release the audio. You couldn't get the video. So this is the brief filed by the attorneys that represents the Associated Press, Radio, Television, Digital News Association, Sinclair Media, of Boise, Newsroom, DBA, Idaho Capital Sun, Tegra, and a bunch of other news, or New York Times, WP Company, LLC. There's a bunch of them. So I think it's interesting to know, because as I have said on here, I think that every courtroom should be made available to the public via video, just like you have, little cameras posted all over cities and things like that. And you should be able to go in at any time to see what's going on in a courtroom. I don't care. It's the people's court. It's the people's building, right? They always say that. It's the people's building. Just don't come in here. Or if you do come in, make sure you go through security. No. We understand that bypass over there. That's for district attorneys, court staff, and judges. Everyone else, including, you private defense attorneys, you can't come in this way. All the unwashed must go through the security screening. So let's get to this brief. I think it's interesting, and just kind of compare what it says. So remember, this is the press trying to get access to the Brian Kohberger trial when it's televised. It says, as the court knows, this case and the murders that preceded it have forever impacted the University of Idaho, Moscow, and the state of Idaho. The people impacted, many of whose lives are forever changed and sense of security undermined, deserve an opportunity to see and hear the court proceedings for themselves. But the realities of everyday life prevent most citizens from attending the proceedings in person. Interveners, through print and electronic coverage, serve as surrogates or facilitators for those who have been so impacted, and for others who wish to observe their criminal justice system at work. Now, the Idaho Court Administrative Rule 45 appreciates the fact, and it allows the court to authorize audio and visual coverage of the proceedings here, subject to carefully crafted rules designed to protect the state's and Mr. Kohberger's constitutional interest, the privacy concerns of jurors and trial participants, and the dignity of the courtroom. Audiovisual coverage will provide the best opportunity for impacted community members in Moscow and throughout the state to receive contemporaneous, complete, and objective evidence about this case as it will be presented in the courtroom in a rational, dispassionate, and orderly manner. Interveners thus urge the court to exercise its discretion to allow such coverage. And they go to the background. On November 22nd, 4 University of Idaho students were murdered at a home near campus. The tragedy caused sorrow and fear throughout the University of Idaho state and near Washington and the nation. The community followed the investigation of the murders closely, many fearing for their safety on or near campus and providing information to law enforcement whenever possible. In December of 2022, Brian Kohberger was arrested and charged for the murders. He has since been indicted, arraigned, and set for trial on October 23rd. The community is eager to learn what evidence shows about Mr. Kohberger and these heinous acts, and if the prosecution will bring closure and a return of a sense of safety after the great tragedy. Mr. Kohberger's trial will likely be the only time when the community can learn directly about what inculpatory or exculpatory evidence, learn about the thoroughness of the investigation or any missteps, assess the fairness of Mr. Kohberger's prosecution, and evaluate whether this great tragedy has ended. For these and other reasons, this case remains the first case listed on the judicial branch's case of interest, even above the prosecution of Chad Daybell and Lori Vallow. Now, interveners are a coalition of media companies that have and will report on Mr. Kohberger's prosecution. On May 1st, they filed a motion to intervene and a motion to vacate the amended non-dissemination order along with accompanying memoranda. At a May 22nd, 23 hearing, scheduling conference on those motions, the court invited interveners to submit this supplemental memorandum on camera access in the courtroom. Recognizing the benefits to the community and the integrity of the judicial system. Who does that sound like? This guy. Recognizing the benefits to the community and the integrity of the judicial system, Idaho is more open to media coverage of trials than other states. It allows audio-visual coverage of public district court proceedings, which means broadcast, video, audio, and photographic coverage, with broadcasting including a wide range of transmissions such as television, radio, internet, email, and streaming. Idaho Court Administrative Rule 45A is what provides for that. Accompanying that authorization are many safeguards to maintain confidences. Limit dissemination of information that would not be accessible to those attending in person, ensuring the right to a fair trial, protecting privacy interests, and preserve the dignity of the courtroom. Most important to the presiding judge's discretion, the presiding judge maintains complete discretion to allow or limit audiovisual coverage free from appellate review, which I think is absolutely unbelievable. There's no appellate review on a constitutional issue in the state of Idaho. Are you kidding me? Blows my mind. Yeah, let the state violate the First Amendment, but you can't do anything about it. The district court judge said you couldn't do it. If they don't grant cameras here, I hope this group of media broadcasters, print and media, say, no, we are going to appeal. I mean, go to the U.S. District Court for some sort of extraordinary relief. You cannot prohibit that. Anyway, the many community members throughout the University of Idaho, Moscow, the state of Idaho, and the cities in which the victims' family members reside who are impacted by this heinous crime committed this past November should have the opportunity to see and hear those proceedings for themselves. Audio-visual coverage will provide the best, most objective opportunity for the many community members who will be unable to attend in person. The court should thus afford those community members the opportunity, while strictly enforcing, as it must, Idaho Court Administrative Rule 45, safeguards to protect all other interests. The recent prosecution of Derek Chauvin and Lori Vallow, not to mention Mr. Koberger's arraignment, show that allowing audiovisual coverage is the right decision, as Mr. Chauvin's conviction after a broadcasted trial was largely accepted, whereas Ms. Vallow's conviction after a trial that was not broadcast is currently being questioned after reports that a juror relied on evidence that was not presented in court. Public proceedings are central to our justice system. It would be difficult to single out any aspect of government of higher concern and importance to the people than the manner in which criminal trials are conducted. And they cite to a United States Supreme Court case, Richmond newspaper v. Virginia, for that proposition. As a result, the right to attend criminal trials is implicit in the guarantees of the First Amendment. There is thus a presumption of openness of court proceedings that may be overcome only by an overriding interest based on findings that closure is essential to preserve higher values and is narrowly tailored to serve that interest. Thrown in the old Constitution there. I love it. The First Amendment guarantees the right to access because it enhances the quality and safeguards the integrity of the fact-finding process, with benefits to both the defendant and to society as a whole. Citing to Globe newspaper v. Superior Court. Public access to criminal trials fosters an appearance of fairness, thereby heightening public respect for the judicial process. And they also cite to a Supreme Court case. Knowledge that anyone is free to attend gives assurances that established procedures are being followed and that deviations will become known. Access also serves as a therapeutic and prophylactic purpose, providing an outlet for community concerns, hostility, and emotion, citing Richmond newspaper. Without an awareness that society's responses to criminal conduct are underway, natural human reactions of outrage and protest are frustrated and may manifest themselves in some form of vengeful self-help. Considering these many interests furthered by open trials, mere openness to those who can travel to the courthouse is not enough. Trial courts are obligated to make every reasonable measure to accommodate the public's attendance at trial. Once again, citing United States Supreme Court case law, Presley v. Georgia. Finding constitutional violation where trial court excluded defendant's uncle from voir dire because 42 potential jurors would be sitting throughout the courtroom, and there just isn't space for the public to sit in the audience. Can't do that. You can't kick people out. Cite another case, Eighth Circuit case, allowing only 25 members of the public to attend a trial when the courtroom could hold 100. Reversible error. Allowing audiovisual coverage is a reasonable measure that this court can take to ensure all members of the affected community have a chance to view Mr. Kohberger's prosecution. To be clear, interveners are not asserting here that the First Amendment compels the court to allow audiovisual coverage. Interveners are arguing that the court should exercise the discretion afforded to it by Idaho law to allow more citizens to observe the courtroom proceedings. Ideally, every citizen should be able to satisfy himself with his own eyes as to the mode in which a public duty is performed, citing a case from 1884 by Justice Oliver Wendell Holmes, Cowley v. Pulsifer. But the reality is that most people affiliated with the University of Idaho, Moscow, Pullman, and the other communities touched by these crimes, as well as those in Pennsylvania where Mr. Kohberger is from, simply cannot attend the court proceeding in person. The limitations of daily life means that most court citizens must learn about Mr. Kohberger's court proceedings not by attending themselves, but through the news media. This case is newsworthy and will be extensively covered by the news media, no matter if electronic journalists may use the tools of their trade inside the courtroom. While both print and electronic media serves that important surrogate role, only the electronic media can provide the public with a close visual and aerial approximation of witnessing a trial without physical attendance. That is, broadcast comes closest to allowing citizens to observe the proceedings with their own eyes and ears. Permitting recordings and telecasts consistent with Idaho law of the proceedings that take place inside the courtroom will ensure that the information conveyed by the news media to the public is contemporaneous, complete, and objective. Such coverage will convey the evidence as it is received in the courtroom setting, its rationale, dispassionate, and an orderly manner. Without a camera in the courtroom as an objective observer, the public will be forced to rely on selective summaries of those members of the media who are able to secure a coveted spot in the courtroom. On the other hand, electronic coverage of proceedings allows citizens to have a firsthand view of the case as it proceeds under the control of the presiding judge and allows them to make their own unfiltered assessments. Given the effect of the crime alleged on the community at large, it is particularly important that in order to understand whatever verdict is rendered, the same community be able to see and hear the case presented by the prosecution and the defense. As the United States Supreme Court noted, people in an open society do not demand infallibility from their institutions, but it will be difficult for them to accept what they are prohibited from observing. I love this stuff. Interveners do not know the state or Mr. Kohberger's position on cameras in the courtroom, but they assume that if either objects, it will be because of the perceived effects on the right to a fair trial, the privacy interest of witnesses, and courtroom decorum. Idaho Court Administrative Rule 45, which interveners, of course, must and will strictly follow, addresses all of the concerns. If community members are allowed to observe audiovisual coverage of the proceedings, their observations will be no greater than those of community members who are able to attend in person. And a criminal defendant's right to a fair trial is not infringed when open proceedings are exposed to even more sunshine. Rule 45 does not permit coverage of more sensitive aspects of the proceedings, like conferences between Mr. Kohberger and his attorneys, conferences between co-counsel, sidebars between counsel and the court, notes of counsel table, unadmitted exhibits, in-camera sessions, closed proceedings, or judicial deliberations. The Idaho Court Administrative Rule 45C states that the court may also impose limitations on the coverage of the jury, including during jury selection. And if there are concerns about the accurate effect of the coverage of a particular witness, then those concerns can be addressed on an individual basis. The presiding judge states Idaho Court Administrative Rule 45D, the presiding judge may exclude audiovisual coverage of a particular participant or direct that the identity or audio of a participant be concealed upon a determination that such coverage will have a substantial effect. There are also rules that have no minimal effect on courtroom decorum. The news representatives must determine among themselves who will capture photos and recordings of the coverage, and it will be pooled. No electronic flashing, camera noise, no video or television cameras. Media representatives must be in position at least 15 minutes before the court begins and shall not change positions while the court is in sessions. And media representatives must be present, conduct themselves, and keep with the dignity of the court proceedings. And the media coverage should be pooled to limit the number of media representatives in the courtroom. What is more, allowing the coverage will reduce the amount of foot traffic and the corresponding potential for disruption at the courthouse. The coverage of Mr. Koberger's arraignment provides a prime example. The Associated Press, just one of the interveners, intended to send 2 or 3 representative covers Mr. Koberger's arraignment. Declaration of Gilliam Falkus. They have a bunch of attachments here. But when the Associated Press learned that there would be pool coverage of the arraignment, it instead sent 0 representatives to attend in person because it knew the pool coverage would provide the information needed to accurately and fairly report on the arraignment. Relatedly, interveners expect that the future proceedings will be at capacity. Allowing cameras in the courtroom will reduce the competition for limited seating and ensure those who are unable to secure a seat, including reporters, can still observe the proceedings. To be sure, if cameras are allowed in the courtroom, more impacted community members, including members of the University of Idaho, Moscow, and Idaho communities, will be able to see and listen to the courtroom proceedings with their own eyes and ears. But the existence of more observers should be viewed positively, not negatively. That's what I say all the time. All impacted community members, not just those that have the time and resources to wait in line and attend in person, should have an opportunity to experience the benefits of an open courtroom proceedings. The rights of the trial participants will not be affected, as those listening or watching from afar will not obtain any information that is unavailable in the courtroom. In fact, it would be better for the state and Mr. Koberger if impacted community members can observe the rationale, dispassionate, and orderly presentation of all the facts, rather than relying on repackaging from potentially unethical outlets or anonymous online commentators. Mr. Koberger would also further benefit from many advantages of an open trial. The proceedings themselves will be more streamlined, and there will be less need for competition each day to secure spots in the courtroom. Recent high-profile cases show that courts should allow cameras. Criminal trial of Derek Chauvin posed several unprecedented challenges. First, few, if any, cases give rise to a social justice movement the size of George Floyd inspired, and it all happened during some of the darkest times of the COVID-19 pandemic. The Honorable Peter A. Cahill presided over Mr. Chauvin's trial. At the time, he opposed the use of cameras in the courtroom in criminal cases, and they have a declaration of Wendy J. Olson, Exhibit A. But he ultimately allowed them during Mr. Chauvin's trial, and that experience changed his opinion, such that he now believes cameras in the courtroom can be helpful in promoting trust and confidence in the judicial process and are sometimes necessary to safeguard both the defendant's right to a public trial and the public's right to access criminal trials. To be sure, Judge Cahill continues to advocate for careful regulation and exercise of discretion, but in his view, there should be a presumption that cameras be allowed in trials and sentencing. By contrast, in the recent Lori Vallow trial, the court did not allow cameras in the courtroom during trial except when the jury returned a verdict. The inability to view audio-visual coverage of the trial did not detract from the public's interest in the trial, but rather than watching and listening objectively to what occurred in the courtroom, citizens could see only stale images and were entirely dependent on the quality of the reporting from those who were able to access the proceedings. Now, Ms. Vallow is challenging her conviction, arguing the juror relied on evidence that was not presented in the courtroom. Because most members of the public could not view the proceedings in real time or review recordings of those proceedings now, well, they could have. They went to CrimeTalk. We've got the entire trial, all the audio right here, conveniently located in one location. That creates potential doubt within the community about the criminal justice system that could have been avoided. Nate Eaton, juror, responds after Lori Vallow, attorney, asked for a new trial. They give a hyperlink. The contrasting experience in recent high-profile cases show that as it did at Mr. Koberger's arraignment, the court should at least start by allowing audio-visual coverage. Interveners are confident the court, with the benefit of hindsight, will be satisfied with the decision, and for the reasons issues emerge again, the court can take immediate corrective action. I totally agree with everything in the brief, and it's not just because I want to be able to see the Brian Koberger trial from the comfort of my home or office, rather than having to go there. I would still plan on going there at some point and trying to watch it, but heck, let's face it, it's a lot easier. I'm a firm advocate. I've been saying you can go back for all years and years and years. I've been saying put cameras in the courtroom. There's no reason that this should be done. And then you got the Lori Vallow stuff where they did all the hearings in chambers. Unbelievable. But yet you kick out one member, of the public because there's not enough room in the courtroom for voir dire. It's reversible error. How can you do all your pretrial motions in the public, outside the public view? Unbelievable in the Lori Vallow case. I hope the judge doesn't make the same mistake as it relates to Mr. Koberger. Now, the problem for Lori Vallow's case is the defense attorneys went along with it. Well, we don't object if you don't object, but it may be, one of those reversible error. The judge should have just done it himself. Like, you can't limit the courtroom, ladies and gentlemen. It's the people's courtroom. It's a public courtroom. People should be able to see what takes place. It will instill trust and confidence, I hope, if people get to see what is going on, so you don't get to second guess it and have a bunch of weird people that have no idea what the hell they're talking about telling you what happened in the courtroom. I mean, I know people say, oh, Scott's going to talk about this, but Lori Vallow, I saw all these people on TV. Oh, yeah, they amended the complaint. No big deal. Amended the indictment. Are you kidding me? You can't amend an indictment. Only in Idaho can you make a pen change. Change the whole statute. The statute that you've been relying upon forever. For 2 years that the case has been charged. Don't worry about it. It's crazy. All right, let's go to some of the comments. I see the Mama Pink gave us a super chat. Now, we don't beg or ask for super chats, but as you can see, it catches my eye when it goes by because it's in a different color. I feel like all this censorship is causing damages to the cases by allowing the rumors and the misinformation run rampant in the media. It is a problem. What is the best, what do they say? Disinfectant for misinformation? It's called the truth. Let people take a look at what is going on. We can do it. They have a couple of these declarations in this case, in motions as it relates to that brief in support. This is a declaration of an Anjanette Levy in support of a motion to vacate the amendment non-dissemination order. It says, since 2020, I've been an on-air host, correspondent, producer at Law News, Law and Crime, one of the members of the media coalition, this multi-platform media company live trial network, and covers true crime, legal news, and high-profile criminal cases. I have over 20 years of experience in broadcast journalism, television production, and news reporting. I graduated from the University of Cincinnati with a bachelor's degree in communications. Over the past several decades since beginning my career in 2001, I've worked as a reporter, producer, anchor, host, and correspondent at various local news radio stations, television stations, etc. Then it goes into the Koberger was arrested. Since the onset of the case, I have been the lead reporter covering this matter for Law and Crime. I have issued various forms of requests for information access in order to provide fair and accurate reporting of information that would be valuable to communities impacted by the murders. Specifically, I have issued documents requested, approached subjects for interviews, and sought to speak with various government officials with knowledge of the matter, even for background purposes. On January 4th, my team and I issued an open records request associated with the August 22nd traffic stop of Brian Koberger, received a denial with the officer citing active prosecutions of one of the reasons. On January 5th, our team issued a public records request for records from the Pullman Police Department in Pullman, Washington, regarding the Koberger's application, essay, material from his fall 22 application for an internship in the Pullman Police Department and received a denial, saying it's an open investigation. And she goes on for all these requests. Denied. And so, in regard to the inquiries requested below, paragraph 8-9 of the declaration, I was explicitly informed I was being denied access to permit information regarding this matter due to the gag order implemented. I mean, ladies and gentlemen, what separates a democracy, a free and fair and open democracy, is the fact that you get, hopefully, the truth. Hopefully, it's going to come out, because it always does in litigation. But if only one side is presented or nothing is presented, well, we can't talk about that. There's a gag order here. If it's factual, how can that be prejudicial to anyone? It can't be. It's a fact. I mean, you look at all of the returns on all of the search warrants that have been issued. T-Mobile, UPS, Verizon, Walmart, Yahoo, Yik Yak, Google, Twitter, all these apps and everything that they get all this information from, and they say, "Oh, we've returned it. Here you go," but nobody can have it. Nobody can have access to it. Maybe we'll let you in if we choose to do so. I just have a real problem with it, and I really don't understand. The prosecution should be saying, "Hey, we want to make sure that the community knows we're doing our job. We believe we got the right guy. We're going to present overwhelming evidence of Mr. Koberger's guilt, and we invite the world to come watch us do our bidding for the people of the great state of Idaho, because we got nothing to hide. We did it right. We'll stand by our officers and how they conducted this investigation. In fact, it was just good old-fashioned police work that's going to get justice for those 4 Idaho students." You would think that's what the prosecutor would be saying. You would think that's what everybody would be saying. Even the defense would be saying, there's a high-profile case. They're thinking about going death on my client. I want to make sure every I is dotted and T is crossed so that my client gets the appropriate due process. And if something comes out and somebody says, "Well, this is a fact," you know what? We have limited resources. We'll take the assistance of somebody that can search the internet for 8 hours and come up with something else. Then say, "Oh, maybe that fact." Well, it's a fact, but it's only one of many facts that need to be considered. I don't get it. I don't understand the prosecution or the defense attorney's skepticism, other than say, "Oh, well, the defense, it's going to be bad, and they're going to think my client's guilty." He's given the presumption of innocence. Yes, there's the legal standard, and then there's the court of public opinion. But the reality of it is that the facts are the facts. They're going to come out. As we saw when they did jury selection for Lori Vallow, there were some jurors that had never heard of the case. And some had heard of it, which is not a disqualifier in the case. They just simply had to be able to put that out of their mind and only listen to the evidence that is presented in court. That's the legal qualification, to make your decision based upon the evidence that is presented in court. Legal and competent evidence. Not what you heard on the evening news, not what you watched on Dateline, only what's going on in court. It is the ultimate check to make sure the prosecution is doing things right. The defense should ask for it. If I were to talk to Brian Koberger's attorney, I would say the best thing you can do is put cameras in the courtroom, man. You just got yourself all these other investigators on the case that could potentially help you. And if somebody sees something that's not right, maybe you're busy, maybe you didn't hear exactly what was said. You've got all those people are going to say, "Hey, what about this issue? You need to re-raise this issue. Think about this." It is not a bad thing for either party. And it's the way the process works. People have trust and confidence. I totally agree. We talked about this before, even this brief. The Derek Chauvin trial, remember, all they kept talking about is the city was going to burn, whether it was guilty or not guilty. But if people had interest in it, you watched the entire trial from beginning to end. And you said, "Yep, I get it. Guilty. George Floyd may not be an angel. Don't particularly think I approve of a lot of things that he was doing, like crack and fentanyl and all that good stuff. Not supporting his kids. Not a great guy. But Derek Chauvin, even worse guy. Bad facts, right? The city didn't burn. Frankly, I don't even think there were any protests. I think they were pretty satisfied. And Judge Cahill, as this reporter put in her affidavit, says that I was kind of opposed to it, but I think it worked. It instills trust and confidence, ladies and gentlemen. So I don't know. I just have a real problem. I'm a big believer in all the information getting out there, even bad ideas, even things that are purportedly false, because they will be proven false. But the only way you get to the truth is you have to have an honest debate. You have to have counterpoint. And when people run out of points and counterpoints, you start to recognize that their argument is weak. What's wrong with that? Only people that don't like that are people that really don't want the truth. And in my practice as a criminal defense attorney, I'm the mayor of Realville. I can't sit there and make arguments that, no one can make a straight-faced argument about, because then my client's going to jail just to say, oh, I think this is the way it should be. It's not politics. It's facts. It's evidence. It's the law. And you can't ignore the facts. You can try sometimes, but those pesky facts keep coming back over and over and over again. All right, let's go ahead and see what we have to say. Mandy wants to know, what can Lori Hellis do about the judge treating her so poorly? Just keep fighting. Refile her motions, that he says that they were somehow administratively deficient. Really, Judge? Really? You had a bunch of prosecutors in your courtroom that couldn't figure out the statute that they were going to prosecute Lori Vallow on until 30 minutes until they closed their case. But yet Lori Hellis files a motion and she doesn't put in a appropriate comma, and you reject her pleadings. I mean, it is obvious just by the tone of the pleadings, the order of Judge Boyce. For whatever reason, he does not like Lori Hellis. I'm just calling it the way I see it. I think it's very obvious. He, gets little digs in. Even at one point, a little footnote that all those women who heard herself as an attorney is not a member of the Bar of Idaho and was the only person that got kicked out of the courtroom in the Lori Vallow trial. Wrongfully, I would submit. I've spoken with Lori Hellis. Since my understanding, somebody said it was the defense said she took a picture. She took a picture. The sheriff looked at her phone, saw no picture that was taken, but she was still kicked out. She was sent down to timeout, couldn't come back up. I think she was going to have to genuflect in front of the judge and say, "Oh, I'm sorry, Mr. King. Please let me in again." And I don't think she was willing to do that. So I don't know. I what do people have against the truth? And you may not like the truth, but it is the truth. That's just the way it is. That's right. Welcome to Realville. Good evening, Mayor. Judge Boyce is a big crybaby. I think he's just young and kind of immature on the bench. And let's see here. Mama Pink or Tanya. I can't wrap my head around people not liking, even when CrimeTalk paid to have the trial presented to us at a cost to them, people still don't like. Talking about, liking the page or whatever, like I said, the drill. Subscribe if you haven't, like if you do, leave me a comment, hit that little bell. Listen, some people, we do what we do. We take their business decisions as to what we should do. Like the audio recordings, we got those every day. I mean, that was not necessarily inconvenient for me. It was more of an inconvenience for Frank because sometimes we didn't know when they were going to come, right, Frank? Sometimes they arrived at like 4:30 Mountain Time. Other times they came in at like 8 p.m. I think once they even forgot until the next day. So we just had to wait. But we do what we think people want to watch and see, and we're going to continue to try and do that. Which brings me to a question, and this is what I really need to know what you guys want to do. I know it's kind of shifting gears here, but obviously we've been doing our show now for a while. We've been bringing you trials when we can. But what else would you like to see? What other cases would you like to see covered? Frank and I are, there's only so many hours in the day that Frank can work and to do things, and same as for me. Julie left us. Gosh, was it almost a year ago now, Frank? Yeah, I think so. And just didn't find the right replacement yet. But we'll figure that out here soon. I think we need to do something. But let me know what you want to think. I mean, what else do you want to see? What cases interest you? How do you all decide what cases you think are going to follow? Obviously, I like cases where I think there's going to be good lawyering involved, and somebody hasn't basically confessed. I mean, when they confess and whatever, it's just a long, drawn out guilty plea. I like cases that are actually contested. Yeah. So that's what I like. I like contested cases, good attorneys, where we got a real issue where we're going to be able to, like a whodunit. We love the whodunit stuff. And a lot of people, I mean, like I said, some people make so many decisions early on in a case that something, this is the way it is, this is the way it isn't. You just got to kind of wait and see. There was, what was it? The lady that disappeared the other day, and they thought that she had been kidnapped. And this was like the Gabby Petito story. We didn't talk about it because they said something just doesn't seem right. And then the woman like showed up. You got to be kind of selective. I think at least we try to make sure we get it right and not just jump on some, bandwagon of what's taking place that particular day. So let's see. Tanya loves the truth. Yeah. Lori Daybell's lawyers was so unprofessional, says Teresa KS. I don't know if it was unprofessional. I just didn't like their style, but that's the thing, that's their style. Obviously, it didn't work with this jury. Maybe it works with other juries, but I don't know. Lulu wants old cases where the prosecution failed, like actual innocence type cases. Corin Richens, and then I get other people over here. I see a comment come through on another thing. Love your channel, but I hate your background. It looks trashy, too much going on. It looks like my house. Okay, well, it is what it is. We've changed up our, channel for a little while over the years. We kind of keep it. I look back at some of our early videos. Oh my gosh, I cannot believe some of the stuff that I put up. It was so bad. But we were learning. We're still learning. Every day is an adventure. Always learning about Murdoch boat crash trials. That was a good one. Yeah. Mama Pink loves the background. Looks like my house. Yeah, and here's the one thing I've learned from doing this. I think we're going, 5 years now total? No matter what I do, no matter what I say, no matter what set we show up on, somebody will not like it and they will let us know, which is fine. But what I have noticed, and I really like people getting away from it. People are like, I didn't like what you said. I'm unsubscribing. Okay. And then you see their same comment, commenting a day later. That was their thing. If you must agree with me. And we've never been about that. Like, hey, we try to call it the way it is. I think I'm a pretty fair to both sides. Call it the way it is. Somebody does a good job. I think the defense in Lori Vallow, they made some good legal arguments. I don't think the judge understood the legal arguments. I don't think the prosecution did. Like I said, and I'm telling you, if I was prosecuting a case, and let's say you were like a civilian, an attorney, civilian, like in plaintiff case, and you pled your case under the wrong statute, you know what you'd be doing when you start packing up your bags because the judge said, no, you're not going to be able to amend your complaint? You'd be walking out, contacting your malpractice carrier and telling them, I need to report a claim. It's coming. Okay. Same thing if you were the defense attorney and you got up and said, oh, I thought, Judge, yeah, I was here the whole time. I didn't realize they were doing this statute. In fact, I even asked you guys which statute you think I should be defending upon, and you guys said, you have everything you need. And someone said, I was prepared for a different statute, Judge. I wasn't prepared for that. You'd be contacting your malpractice carrier. You would be telling the next attorney down the road, yeah, you probably want to file an ineffective assistance counsel claim with me. But prosecutors do it, and it's no big deal. Oh, they're prosecutors. No worries. We're going to change the rules for them on everything. Those hard deadlines, they're prosecutors. Don't you know how busy they are? They don't have time to respond to motions that you all had to write. It's just the way it is, ladies and gentlemen. Hell, I had pleadings filed 4 months ago. I said, hey, can I expect some of this information, this discovery coming my way? Oh, you don't need that. You're not entitled to that. Well, I want any co-conspirator statements. You're not entitled. There's no co-conspirator statements. And then I get a motion today, 4 months later. Oh, we want to introduce co-conspirator statements. And I'm telling you, it is my pet peeve, ladies and gentlemen, is that I'm not the smartest guy in the world. But you can even say I'm a high rep learner, but I've been high rep learning for 28 years. I kind of have a pretty good idea what's coming next, how it's going to play out. Not that I'm the most brilliant guy in the world, just that I've seen it 100 times under the same circumstances. And when some little junior little prosecutor over there dismisses me like I am an idiot, and then I got a judge that looks at me who's got no experience in criminal law whatsoever, looks at me like I have a third eye on my forehead, and then I get to come back and say, maybe you should listen to me, Judge, and not the little twit over there on the other side of the courtroom. Just saying, do what you want, Judge. Do what you want. But I think I usually go with some experience. Like, I'm an officer of the court. I cannot, pull the bag over your head and say, do whatever I want. It's not going to happen. I still you have to make a record. So it's just that's the part of stuff that just irritates the hell out of me. Seriously. All right. Do we have another super chat there, Frank, that came in? I would be interested in your thoughts on the Zachariah Anderson verdict. Same judge as Kyle R. trial. State didn't prove their case, in my opinion. I have not watched the Zachariah Anderson trial, so I really can't comment on the verdict. I apologize for that. Southern Mom, since I don't have a good answer for you, put up another question, and I will attempt to answer that for you. I don't even remember Zachariah Anderson trial coming on my radar at all. I just don't even, that name doesn't even ring a bell. Does it ring a bell to you, Frank? See, maybe we need more people to send us information on cases that they think are of interest. Like I said, we only have so many hours in the day. There's only so much research I can do as I wake up in the middle of the night trying to think, what else can we talk about? We need more information. We need to do this, trying to do research on stuff. Oh, look, Mama Pink just got her new CrimeTalk t-shirts. Look at that. Sweatshirt is still on the way. Okay, that's that. We'll be watching for Southern Mom if she wants to set up another question. Sorry, Southern Mom. So just like at bars, throwing a fit and then coming in the next day and apologizing to everybody because they were the floor show the previous night. Mm-hmm. Yep. Or the machete. What about the machete? Over here to my left, I may have, the K-bar and the machete and other instruments here. But we have found that if we show the machete or even the K-bar, we get demonetized. I know. Because there's some people out there, you just can't handle the truth. Can't handle it. We're trying to bring you the truth. How about if you lie to a grand jury to get an indictment? Well, you're not supposed to lie to the grand jury. That would be perjury. You can't lie. You're under oath, under the pains and penalty of perjury. But now let's face it. When was the last time you really ever saw somebody prosecuted for perjury? You didn't. You didn't. You haven't. Because it's at the prosecutor's discretion. And if they're prosecuting for, I always have clients, they're perjuring themselves. Well, not according to the district attorney. They're just providing evidence that you don't like. That's not perjury in the eyes of the district attorney. Just saying. What's this here? Nana? How do you get Scott to answer a question when I can't afford a super chat? I'm not trying to be a smart ass. Nana, ask your question. I will ask it again. Okay. Stephanie says here on the super chat, Rittenhouse trial proved cameras got truth openly displayed for all to see. So many prejudged. Absolutely. Totally agree. The Chauvin case is an absolute great example of cameras in the courtroom. I mean, yet everybody's spinning it their own ways. Bottom line you got the video. People saw the video. They got to hear the testimony. They got to hear the defense put up a guy who says, hey, it's reasonable to do that. Maybe not as long, but and the jury got to weigh the credibility just like everybody else did. And they're like, yeah, I see how they could come to that decision. The Rittenhouse trial. I'm sorry, I was getting Chauvin confused. Rittenhouse. A lot of people prejudged the Rittenhouse trial, but then the camera showed that he was in fact the victim. All those guys coming attacking him, and he shot him. And once again, the city's gonna burn. Well, it didn't burn because people saw. I see how the jury could come to that conclusion, and that's why when you see verdicts that you don't like, unless you've watched every second of it, you really can't criticize it and say, well, I would have found him guilty. Well, you weren't there. You didn't see the evidence or see the lack of evidence that was presented in a case. And so I just think that's well, thanks, Jennifer. I watch all the time. Told my husband if I ever get in trouble to call this man. No one else will do. Get me Scott. All right. Well, hopefully, and I mean this in the nicest way, hopefully you never get in trouble. Does your law firm do any special ed law cases? No. Okay, I'm looking. His Southern Mom. Okay. Okay, Nana says I put her question. She put her question in twice. Sorry. Frank, you think you can find Nana WWG1WGA? See what her question was? Can you see? I'll take a look at that. You can recognize the patterns. Yes. Yes. Crime Talk. The question from Nana was, her question was, Once a case has been dismissed, can a judge address motions for that dismissed case in Colorado? I don't understand what motion there would be after the case was dismissed, and maybe accept return of property or something. But once the case is dismissed and the court signs it, the court loses jurisdiction over the case. So there's really not much that could be done. Hope that answers your question, Nana. Peace out, Lisa. I would like to see Scott in action. Well, I'm going to be busy all of July. Although this case is coming together, I think we're going to do all right. Teresa, my first, and he mentioned one of my comments. Yes, it's just kind of random. It just happens sometimes. Jennifer M. Preach. Love your channel. Your background is spiffing. Thank you, thank you, thank you. We appreciate that. Love you in the UK. Thoughts on Judge Scheer? She is the judge that got her public censure. We talked about that today. Oh my gosh, why am I blanking on the kid's name? It was the shooting down in Florida. 15 students died, teachers, etc. Anyway, she was down there. She was not a very fair and impartial judge throughout the trial. And you remember she got all upset when the defense rested early. Well, we had all these people in here and blah, blah, blah. She was just rude. I was like, not very respectful. And I'd be like, well, the defense has been mean and nasty the whole time. No, they're doing their jobs. Okay. They're doing their job. And the judges are supposed to maintain their composure at all times. She didn't do that. Now she's resigned and she says it has nothing to do with her public censure, but let's admit it. She does. Maybe she realizes this is just not her gig, not her jam. And I get that. I've known people that have been judges and quit because they're like, it's just not what I thought it was going to be. And maybe that's what this judge, I think she was there for 10 years or something like that. But you don't go down hugging the participants. You just don't do that. The prosecution, I offered a hug to the defense as well. Yeah, the defense doesn't hug, right? There's no crying in the courtroom from the defense. No. No. Gaga Holiday, $99, $199 super sticker. Let's see. Scott, did you see the video? This is old, I think, right? The councilman was found in his vehicle with a crack pipe. I'm sure he's fine. I'm sure he probably got escorted home, right? I don't know. It's just crazy. What is the we did a story today. The lady that had her son in Virginia, 6-year-old that took the gun to school and shot the teacher. She's getting federal charges because when she bought the gun, they say that she lied on her application because she was basically addicted or used marijuana, which, like a lot of people have forgotten, it may be legal in the States, but it's still criminal to possess it, use it, all that good stuff. And one of the questions when you buy a firearm, are you addicted to any drugs, anything like that, regular user of, and includes marijuana. She's pleading guilty to that. I mean, granted, would they have ever looked at her paperwork had her son not shot the teacher? Nope. Doubt they ever would have even noticed. Think about it. The thing was, hey, if you smoke that stuff, better be careful with your guns, because if anything happens, they're coming for them. Because now, guess what? The woman's not she's going to have a felony conviction, and she's not going to be able to possess a firearm. Not that she was a good caretaker of her firearm. She probably deserves that. But yeah, it's just the way it is. I don't know. It's just a crazy world. Maria says Zachariah Anderson is guilty as sin, and his lawyer was as green as emojis. Rest in peace. Wisconsin case. The one I hope they put up, maybe it won't go to trial, but the lady that chopped up her boyfriend that she met online or something, that attacked her attorney in court, I think that'd be a good one to watch. See, now here we got the prosecution didn't prove anything in the Z Anderson case. Now I'm curious. I got to go back and look. Cover the Corey Richens case out of Camas, Utah. Look, the CBD oil is working like godsend to my little Tootsie Roll dachshund. Baked in Colorado, ladies and gentlemen. Good timing, nice transition. Get it for your little dog, right? They take out all the bad stuff from the hemp and they make CBD oil. It's all the good stuff. It's all the medicinal stuff. And everybody heard of all the good stuff it does for people. It does the same good stuff for your little dog. Just saying. If you love your dog, get some Baked in Colorado. Wow, we have a lot of questions tonight. I'm really far behind here, Frank. Let's see here. Oh, Nicholas Cruz. Yes, somebody. See, we have the smartest audience ever. All right. Okay, now I'm really curious about the Z Anderson case. We didn't watch that. Young defendant lawyer made some good points and reserved a lot of appellate grounds, which is good. Yep, don't take my word. Take lockdown with April C. There you go. All right. Well, it's already over an hour. We got to go do our Patreon show. So if you haven't become a Patreon, now would be a good time to do so. And you can join us on the side. And we'll talk about what you want to talk about. Obviously, we talked about the Koberger case this evening. And I'm just a big fan of the First Amendment. I really am. And when the government starts telling you what you can watch, that's a problem. You can decide what you want to watch, and you can make your own decisions. But light is the greatest disinfectant. And when they turn on the lights, you see all the little cockroaches run away. So it's always best to have the truth and openness out there. Why do you think our government does their business in public? They're supposed to, right? They can go in those little executive sessions and little city council meetings and what have you to discuss, litigation. But they can't, everything else has to be done in open public. That's the way it's supposed to work. Same thing with our courts. That's why it just flabbergasts me that the Lori Vallow case was basically done pretrial in chambers. Unbelievable. All right. Thanks for watching. We'll see you next time. We'll see all our Patreon people here in just a couple of minutes. Have a wonderful night.